Hi everyone and welcome to LawSikho series on learning the law. In today's discussion, we'll talk about non-joinder or misjoinder parties under Rule 9 of CPC, Order 1. Now, in the previous video, we discussed the relevant conceptual understanding of necessary and proper party, which is required in this video to understand. So if you have missed it, you can go and check it out in our previous videos of Order 1, that is parties to suit. Now, let us assume a situation. We'll talk about non-joinder of parties first. If we break up this term non-joinder, it will it means the one who has not been joined. So now it is where a person who is either a necessary party or a proper party and he has not been joined in a suit. That is considered a case of non-joinder of parties. Second is misjoinder of parties. Misjoinder, if we again break up, so it is misjoinder, that means a case of default. So how it happens? Let us say any person, he has been joined as a plaintiff or defendant in a suit in contravention of Rule 1 or Rule 3, what we discussed. Rule 1 we discussed about joinder of plaintiff, and Rule 3 is joinder of defendant. So where under it is stated in Rule 9, misjoinder means where a party, neither necessary party nor a proper party, but still he has been joined, dragged in the civil suit. So that will be considered a case of misjoinder. Now let us understand their implication, what it says. Rule 9 says no suit shall be defeated by the reason of misjoinder or non-joinder of parties. That means if in cases of non-joinder or misjoinder, the suit shall not be defeated. And the court may even may in every suit deal with the matter in controversy so far as regard the right of interested parties actually before it. Now, this proviso here, the proviso which we have, is introduced by the 1976 amendment. Why? Because the initial reading, plain reading of initial part of opening part of Rule 9 says that no suit shall be defeated because of misjoinder or non-joinder, and that created a lot of havoc. Why? Because in case of misjoinder, random parties are being joined in the suit. So it causes harassment and it defeats the purpose of justice. So an entire proviso has been added by the 1976 amendment, and it says that in case of non-joinder of necessary party, this rule shall not apply. That is, Rule 9 will not apply to cases of non-joinder of necessary party. That means if X is a necessary party to the suit and he has not been joined in the suit, Rule 9 will not apply. That means the suit shall be defeated in case of non-joinder of necessary party. Let us understand with this with an example. Let us assume a suit of partition of any property of a Hindu undivided family. In any case, a co-partner is not included there. So that will a co-partner has a legal right to the property and he is a necessary party. In case he is not joined in the civil suit, the suit will be hit by Rule 9 and it will be defeated. This is an excellent example of Rule 9. Now moving further, when can objections relating to Rule 9 be raised? That is, objection relating to non-joinder or misjoinder of parties can be made. So Rule 13 of Order 1 discusses about it. That is, all objection on ground of non-joinder or misjoinder of party shall be taken at the earliest possible opportunity. And it further says, unless the ground of objection has subsequently arisen, and any such objection not so taken shall be deemed to have been waived. So here we talk about one waiver of the objections in case the objections are not taken at the earliest opportunity. That implies the objections have been waived by the parties. So this is all about joinder of parties under CPC Order 1. In the next video, we'll discuss about representative suit, which is a very important topic and quite frequently asked in judicial services exams or other APOs, public prosecutors. So stay tuned. Thank you.